All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning, everyone. Today we will continue to hear the evidence of prosecution witness W04571. Before the video link, well, it is connected, but before the witness comes into the room, the panel has considered the submissions of the SPO and the defense about the admissibility of the documents marked for identification yesterday. That is P01064 and P01065. Any idea what that noise is? Oh, okay. Following the request of Ms. Rowan, and so the panel's decision is fully informed by all relevant considerations, the panel will, in this particular instance, reserve its ruling on the admissibility of the documents until after cross-examination. However, in advance of its ruling, the panel would like further oral submissions from the SPO on the admissibility criteria, in particular in respect of both documents. The panel seeks further oral submissions on how the documents were originally obtained, how the documents came into possession of the SPO, and whether the SPO intends to call anyone to testify about the provenance of the documents. In this regard, the panel refers to paragraph 46 of the Order on the Conduct of Proceedings, stating that the panel expects the tendering party to have taken reasonable steps to ensure that the evidence placed before the panel is capable of a reasonable belief for the purpose for which it is being offered. It is the party's responsibility to be in a position to provide information regarding the origin of an exhibit and what steps were taken to verify that information in question is capable of reasonable belief when questioned to do so by the trial panel. Next, the panel would like to know more about the SPO, what the SPO says this document establishes that is relevant to the SPO's case. In other words, what does the SPO intend to prove with these two documents? Will the documents be shown to other witnesses, and why have they been tendered through this particular witness? This will assist the panel in panel's determination regarding the relevance and probative value of these items. Finally, are the purported translations shown to the witness complete? In other words, are the pages in the entire notebook that has been tendered and the single-page document translated completely, as the volume of handwriting does not necessarily match the volume of translation shown in English? The panel invites the SPO to make further oral submissions after the conclusion of the evidence of this witness. So we are ready to begin. We will call the witness into the courtroom. Madam Court Officer, thank you.
Thank you, Your Honors. Just for the record, this is KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Kresnici. Thank you.
Your Honors, for the record, in the transmission room present are witness W04571 and myself, court officer.
Thank you very much. Witness, we will continue with the cross-examination. Mr. Misitich will continue with his questions. Please give him your attention. Mr. Misitich, you have the floor.
Thank you, Mr. President. Before I begin, I just didn't know if you wanted to note for the record that the accused are not present in court. Yeah.
None of the accused are present in court, all attending by video link, and waivers have been filed. Go ahead.
Thank you, Mr. President. Good morning, witness.
Good morning.
We could go into private session.
Private session, Madam Court Officer.
Your Honors, we're now in private session.
Thank you. May proceed.
Thank you, Mr. President. Witness, I want to continue with some questions about what happened to you.
Witness, we will take a half-hour morning break at this time, and then you will be back at 11:30, and we will continue with the questions. Madam Court Officer, you may escort the witness out of the room.
Thank you.
Back to public session, please.
Your Honors, we're in public session.
We are adjourned until 11:30.
All rise. All rise.
Be seated. Madam Court Officer, you may bring the witness back into the room.
My glasses are there.
Your Honors, the witness needs to step out for his glasses.
All right. All right, witness, we will continue with the questions. Ms. Rowans will continue. Go ahead.
Yes.
Yes, I'm going to now ask you about another document that you've already looked at.
Ms. Rowan, we need to be in private session.
We do, Your Honour,
All
yes. Thank you.
Private session, please, Madam Court Officer. My mistake, sorry.
Thank you.
Sorry to interrupt.
No, not at all, thank you.
Your Honors, we're in private session.
All right, now you can continue.
Thank you. Madam Court Officer, could I please have MFI P01065? Thank you. Witness, do you recognise this document as one shown to you by the SPO?
Yes.
You saw, pardon me, this document for the first time in your preparation session with them last week.
Yes, that's correct.
Follows, therefore, that you don't know who created this document.
No, I absolutely don't know.
And therefore, of course, you can't know where this document was found or when it was found.
I don't know.
to assist us with any background information about this document. That's right.
Yeah.
No, I can't.
But like the SPO invited you to do earlier, I'm going to ask for your assistance just in commenting on what we can see on the document itself. So could I please ask you to look at the left-hand side, so where you should see the Albanian version of this document. And would you agree with me that the original Albanian is in typed format?
In typed and handwritten.
So we have the main part of the document in typeface, and on the right-hand side we have a handwritten section as well.
Yes.
Focusing on the typed part of the document, would you agree, and please take the time to do that if you need it, that what we can see on this document your name we see on this document in this handwritten part on the right. Is that correct?
Can you scroll it a bit?
Would we please have the handwritten section in view for the witness? Thank you. There we go, Mr. Witness. You should be able to see there on the right. Can you see your name there in handwriting?
Yes. In handwriting.
There are some other names also in handwriting.
Yes.
Question, but would you agree that that handwriting was obviously not part of the original typed document?
Yes.
You haven't seen the original document?
The first time on that day, and I think I saw it yesterday, and today would be the third time.
Version of the document that you have seen is the version we're looking at now. Is that correct?
Yes.
While I appreciate you cannot know for sure, because this is not a document that you created, but would you agree that it is possible that these names would you agree that it's possible that these names were written on to the typed document that we see beside it?
What, for example? I did not type these documents, I just saw it.
And I appreciate it's difficult for you to comment on a document that you didn't create. Thank you. Witness, you were asked questions about this document earlier on in your evidence. Before we look at the content of this document, again, it's right that you had never seen this document before, shown it by the prosecution.
Siguristiu.
Yes, I didn't see it before.
Able to read a lot of the handwriting that is contained in the original.
Nu pot muita kuten tämä.
I don't quite understand it.
Looking at this document, considering how it is written and the quality of the copy of the document, when you were looking at it, did you struggle at any stage to read the handwriting?
Tuo, epäantavasti.
Yes, I struggled.
Now, the following questions again may seem obvious, but just so that we know where we stand. Again, you do not know who wrote this document.
Nukedi.
I don't know, no.
It's written or where.
Asnielen asiaran.
I don't know.
It was written.
Nukam joi. Nuti.
I don't know about that. I don't know.
And who wrote it?
Absolut.
Absolutely not.
The position of the person who wrote it or their job.
Kädessä paljon primo.
It's completely unknown to me.
And therefore, you can't assist us with whether the vast majority of its contents are true or untrue.
Nukam joi.
I have no knowledge about that.
Take you to the sections that contain your name.
Witness, your testimony is completed. You may leave the courtroom accompanied by the court officer. Thank you for being with us and for sharing your information with us, and we wish you well.
Thank you.
Your Honors, we're now in public session.
Madam Prosecutor, after the lunch break, we will be ready for your submissions on the questions for the issues that we raised this morning. And we will be in a position, hopefully, to make a ruling on the tender at that time. So we are adjourned until 2:30. Something, Ms. Rowan?
Simply, Your Honour, dependent on how long my learner friend submissions are, we could deal with it briefly now and go slightly into the lunch break. Very well.
So thank you very much. We'll see you at 2:30. We're adjourned.
All rise. All rise.
Please be seated. We are in public session. Madam Prosecutor, this morning we outlined some concerns that we had, and we asked you to make oral admissions, oral submissions on that. And so we give you the floor at this time.
Thank you, Your Honor. Following this morning order, I will address the following, the concerns that your honors mentioned this morning. In relation to MFI P 1064, in relation to the authenticity of the document was provided to the SPO by the ICTY and the MICT. The documents were originally provided by the Serbian authorities, which had seized them from KLA bases during the war. And in this regard, I refer to the declaration of an ICTY investigator filed in the Aradinai case. And it's in the Aradinai case, prosecution submissions of chain of custody information for exhibits tendered through Bizdim Zerapi, 7th of November 2007, Annexed A, paragraphs 6 and 13. As there are sufficient indicia of reliability, the SPO does not intend to call a witness to testify specifically about the provenance of this document, although it is noted that there are witnesses who speak to the seizure of KLA documents by Serb forces. This document includes, on its face, indicia that is a contemporaneous KLA record with dated entries, which refer inter alia to KLA members, meetings, and operations around the time of the witness's detention. For example, But to note more generally, the authenticity, relevance, probative value of the document cannot be viewed in isolation, but in light of the totality of the evidence. When you see numerous contemporaneous documents reflecting the same focus on collaboration, the aggregated value is something more than what the individual documents reveal about what was happening in their individual areas. To require absolute proof of a document's authenticity as a precondition of admissibility would be to require a far more stringent test than the standard envisions in the rules and the jurisprudence, which provide for prima facie proof. When objections against evidence are raised on the grounds of authenticity, a trial chamber may admit documents and then decide what weight to give them within the context of the trial record as a whole. And I refer your honors to the panel's decision, FO2157, paragraph 12 and 14. And I note that the SPO included additional supporting authorities from the panels in cases 5 and 7, and chambers at the ICTY in filing FO2135, footnotes 15 and 29. As to what the SPO intends to prove with this document, the SPO intends to rely on this document in relation to the potential reasons for the detention of the witness and that of others, including a person he identifies as his co-detainee. The perceived association with one of the persons mentioned multiple times in the document falls within the pattern we see in relation to other victims of detention in this case, and that is association with the Serbian authorities. In his SPO statement and in his testimony today, the witness acknowledges having had a good relationship with one of the persons mentioned multiple times in the document, including as mentioned yesterday, I note that admitted associated exhibit P1062 contains a statement along with an arrest warrant for this witness and refers to the same person also mentioned multiple times in the document. Another admitted document, which is P00651, page PU00-6593, mentions the witness and provides additional corroboration. This underscores the point that the document, which has prima facie indicia of reliability, should be admitted so that its probative value can be assessed at the end of the trial in light of the entire record. As held by an ICTY trial chamber, the admissibility standard should not be excessively high, as often documents sought to be admitted are not intended as proof on their own of guilt or innocence, but to provide context and a complete picture presented by the evidence in general. And I refer your honor to Delacic case, decision of 19 January 1998, paragraph 20. And that's what both documents at issue would do. The SPO seek admission of this document through this particular witness because he's named on multiple pages and is familiar with other names and locations. The witness has therefore shown sufficient knowledge of the people mentioned in the document, and due to this clear link to an associated exhibit which was admitted through this witness. Thus, this is the SPO position that there is a sufficient connection to the witness testimony pursuant to paragraph 49 of the Order on the Conduct of Proceedings. In relation to translations, my colleagues have checked and confirmed that the translation is complete. Many of the same submissions above are also related to MFI P1065, so I won't repeat them. However, I will make the following specific submission concerning this item. As to its origin and authenticity, the document was provided to the SPO by the Serbian authorities, and page In relation to what the SPO intends to prove through this document, the reasons are very similar to those submitted in relation to the previous documents, since this item also indicates an intent to arrest the witness and one of his co-detainee. Same reason apply for why we're seeking admission through this witness. And as to translation, my colleague also have checked and confirmed that the translation is complete. This concludes my submissions.
Yes, thank you, Judge Smith. I have a couple of questions for you, counsel, if you may assist. Am I right to understand that you are not seeking to tender these two documents for the actual truth of their content, in the sense of the allegations that are being made in them, but that, according to you, they reflect the beliefs of the drafters of this document? Is that a correct understanding?
That is correct, Your Honor.
And specifically about document MFIP 01065, is the witness we've just finished to hear, 4571, is he the only person on this document that you say is relevant to this case, or is there anyone else on that particular document that you say is material to your case?
There is also his co-detainee, and there may be others, but at the time, this is all the extent of my submission.
So at this stage, it's the witness plus the fellow detainee.
Yep. That's correct.
Thank you.
Madam Prosecutor, I just have a question about the evidential status of the prosecutor, or of the statement of an ICTY investigator. And I believe that in your bar table motion for the LAP operational zone, in one of your footnotes, you've referred to the prosecution's submission of chain of custody information for exhibits tendered through Bislam Zarapi, 7th November 2007, Annex A, which is an investigator declaration, a signed and investigator declaration. What is the evidential status of that as far as the SPO is concerned? You're not going to call anyone to testify, so what do we do with that investigator statement?
Thank you, Your Honor. It is not tender into evidence. We rely on it to provide full transparency of what we know. But this is not tender as evidence.
I see. Thank you.
Ms. Rowan, you have the floor.
Your Honour, thank you. Just briefly, and confining the response only to the information that we've now been provided with by the SPO. Firstly, in relation to the first document discussed, P0164, and it follows on from Judge Gaynor's question that was just asked. The SPO are seeking to rely, in terms of chain of custody, to support arguments of authenticity on documents that are not in evidence. We do not have disclosed, and we do not have in evidence the declaration referred to by this investigator. In my submission, it is impermissible for a decision to be based upon submissions made by the prosecution, because, of course, the prosecution can't give evidence. If the prosecution seek to rely upon the content of a statement in support of admissibility of these documents, firstly, that document must be disclosed so that we can consider it, read it, respond to it, see the extent to which it does in fact deal with these documents, what it says about them, and whether or not it does actually stand up to the submissions made by the SPO as opposed to what they can't do, which is give evidence. And in turn, what would be impermissible for the trial chamber to do in my submission would be to find a document to be authentic on the basis of a document that the trial chamber has not even seen. let alone that the parties have not been able to consider. So the difficulty is the starting point for the SPO's submissions on origin fall down, as they're not in a position to do what they're seeking to do, which is make submissions in that way. And as such, origin and authenticity and authorship, because they also appear to seek to rely on what is currently a proposition, not an evidence, that these documents, they say, were found in a KLA base. The evidential position at present is that there is no evidence of where these documents were found. And until the point comes that evidence is adduced to support that proposition, that cannot be a proposition relied upon in the absence of evidence to that fact. So where we are at present is nil evidence on origin and nil evidence on authorship, and as such, nil evidence on authenticity. Again, seeking to clarify in relation to the second document then that they raised, my learned friend for the prosecution says that what the cover sheet document purports to show is a search record of an apartment. But when one actually looks at the body of that document, the document is conflicting. And Your Honours will see when time is taken to review it, the start of the document appears to suggest it is a search record of an apartment. But when looks at two of the bullet points contained on the first page of that document in the bottom half of it, it speaks of items seized of a person. So it appears that in part it reads like the search record of a person, and in part reads like the search record of a premises. So it's inconsistent and unclear what that document actually is dealing with, and as such is unhelpful. And then finally, just picking up on Judge Metro's question in relation to the purpose for which this document is sought to be adduced. In my submission, the purpose for which this document is sought to be adduced is irrelevant to the considerations of its authenticity. Regardless of whether or not a document is being sought to be admitted for truth, or whether or not a document is sought to be adduced to undermine the credibility of a witness for any other purpose, that is a latter consideration. What we are considering now is authenticity as far as it relates to admissibility. If a document is being put in for one purpose or another, does not in any way impact or change the test under 138. The test under 138 remains the same, which is this document a document, which meets each of those four criteria? A document can be, logically, no more or less authentic, dependent on the purpose to which it's sought to be used. Those questions relate to the document itself and the evidence surrounding the document and where that document comes from. And those are the three matters to be raised. Thank you.
A question for you?
I even have two. The first one is you've just made the submission a moment ago that there was no evidence of origin and no evidence of authorship. Now, put aside the submission about an affidavit or statement by an ICTY investigator. I understand the prosecution to be saying that part of their argument regarding authenticity is the actual content of the document. In other words, that the content is a reflection of where this document, they say, comes from. And I want to hear you on this. And I'll add a second question that would assist me at least. Of course, you don't have the onus of establishing the requirements for admission or to dispel them. It's for the prosecution as offering party to do so, but I want to understand what your case is in relation to that document. Are you telling us that these are fake, forgeries, or that you've established evidence of fabrication in these documents, or are you simply underlining your proposition that the prosecution has failed to meet its own burden? Thank you.
Dealing with Your Honour's first question in relation to content, of course content of a document can be supporting evidence of authenticity. That is a proposition we of course accept to be true. I believe that the example I used making submissions in relation to this area of law previously was were we to have, for example, a photocopy of a passport, we would have a...
What about, I'll stop you there, what about what the SPO says? Not in theory, but the fact that it refers to known members of the KLA, that it refers to location held by the KLA, that it refers to operations known to have been led by the KLA. What's
Yeah.
your position on this?
The starting position is, considering the vacuum in which this document appears, this document is incapable of self-authenticating. When we consider both the background of the facts of this case and the context in which this war occurred, and if one looks at the content of the content of that document and the knowledge that would have been required to be possessed to author that document is not a document that could be said to be unique to the KLA. The panel and the SPO are not able to set aside any other inference. This document is just as likely to have been authored by Serb intelligence themselves, because, of course, for example, Serb intelligence may well, were the document to be true, that's not our case, but were the document to be true, there are Serbian authority figures, perhaps Serbian persons, who may well have had similar knowledge that would have enabled them to write such a document. Likewise, of course, one possibility is that the KLA would have had such knowledge. Equally, such knowledge could be in the hands of local civilians. As already established this morning, Kosovo is a small country, rumours are rife, everybody knows everybody's business. And what we say in a context such as that, it is no more likely in the evidential vacuum in which we are operating that any one of those three propositions is true, let alone that it is more likely to be true, let alone that it is beyond reasonable doubt true. Of course, we're not at the latter burden at this stage. But what we are suggesting, in a circumstance where this document exists with nothing else, that the SPO must show that there is some evidence upon which they could rely to support the proposition that this is KLA authored. For example, were the KLA to be in a position to prove or there was video evidence to record a document being seized from an active KLA soldier in uniform, and there was video footage of a notebook being taken out of his pocket and shown on camera. There is evidence there of origin and authenticity. The difficulty is what we are being provided with is scraps of notebook paper from the Serbian Ministry of Intelligence, which we know, because of the ICTY trials that have come before us, that there are members, unfortunately, of the Serbian intelligence with quite a checkered history.
I'll stop you there again. I mean, we're talking about this document. I don't think it assists me, at least, to suggest that something happened somewhere else. I'll ask you the question simply. Do you have any indication that this document is anything other than what it purports to be, and if so, on what basis?
Well, Your Honour, in my submission, that is reversing the burden of this trial.
No. You are free to tell me that you have no such basis for it and you don't have to do it. As I've indicated earlier, you don't bear that onus. What I'm trying to understand is whether you have a basis for the suggestion that this document is anything other than what it purports to be. If the answer is no, it's no.
Well, Your Honour, if we were to phrase it such as this, there is nothing that supports the proposition it is what it purports to be. There is nothing supportive of that proposition. This is a document that comes out of nowhere, with no supporting material whatsoever. Could have been authored by anyone, anytime, anywhere. There is nothing that supports the contention that a KLA member wrote this document. Nothing. Now, the obligation to prove that proposition not to be true, but that at least that there is a prima facie case to answer that it's true, or any indication that it's true, that burden is borne by the prosecution.
Thank you.
Can I ask one follow-up question, please? You say there's nothing to support. Let me see what you said now. The document comes out of nowhere. There is nothing to support the contention that a KLA member wrote this document. I think what we've seen in these handwritten documents is that the same names appear across different documents. The time of arrest, the time of release of certain individuals can be traced through different documents, and sometimes those details appear in a typewritten KLA document which bears a signature that we can read. Does that not satisfy the prosecution's burden of proof of establishing a prima facie case of authenticity? The fact that we see the same details across a different range of these documents.
No, for two reasons. Firstly, because a collection of poorly authenticated or non-authenticated documents cannot create one authenticated document. But more importantly, that proposition would hold more weight were this to be information held by few people, or information that was to be uniquely held by the KLA. As we know, in Kosovo and in circumstances that we're dealing with, everybody knew who was arrested in the village. Everybody knew when they were arrested in the village. Everybody knew how long they were held in the village. That information is not uniquely held by the KLA. That information is information that we've heard from witnesses was widely shared and widely available, both during the war and post-war. So it also can't assist us temporally as to when the document may have been created, because that information and the fact that that information appears in multiple documents simply means that the authors, be they the same or be they different, had access or knowledge of the same facts. Now, it's widely known facts, so that can't narrow us back to the KLA or draw a line back to them as being the authors, because there's no link.
Thank you.
Thank you.
Yes, Mr. President, I'll be brief. Just in a more broad sense, just to express our concern that in terms of some of the submissions, the SPO is relying on, when pressed, an affidavit or a declaration signed in a case that was filed in 2007, and when asked by the panel, their response is, well, we're just telling you what we know. Which to me indicates that there hasn't been an independent investigation by the SPO into the authenticity of the documents that are being put forward to the panel. And it hasn't been put to KLA people. It hasn't been put to witnesses mentioned in the document other than witnesses as they come to court. So it's a general concern that we have. The second point I wanted to make is I have had an opportunity now to check that declaration because it's available online. The source does appear to be the Serbian intelligence service for the document. I would say that there has been evidence before the panel of manipulation of evidence and fabrication of evidence by the Serbian intelligence service in this very case, and including a witness who testified to a fabricated witness statement fabricated by that very intelligence agency. So these are all factors that should be considered. The fact that the document purports to be what it is equivalent to the witness statement that you had in front of you earlier in this trial that would, had it not been exposed on cross-examination, also would have purported to be a witness statement of a witness that appeared before you, but for the fact that we got to challenge that in cross-examination. So, and then the next point I would make is you will hear testimony relatively soon about the fact that Serbian intelligence had in fact penetrated the KLA in the conflict. And so the fact that this information is known outside the KLA, it's in fact the case that will be put forward to you by a prosecution witness that the Serbian intelligence service was not only in the KLA, it was at high levels in the KLA. So this information was not unique to the KLA. It was also in the possession of the Serbian intelligence service, or could have been in the possession of the Serbian intelligence service back in 1998. And ultimately what this comes down to is what happens if the panel accepts the documents, relies on the documents, and then subsequently it's uncovered that this is another fabricated piece of evidence because no one who had actual involvement in the document or potentially involvement in the document testified as to its authenticity, including to the investigators who are now being cited but whose declarations are not being tendered.
Isn't that exactly the reason we sit here, and that is to sort out materials with, if cross-examination later on shows that something was false, it's up to us to deal with that?
Unfortunately, on the substance, I would agree with that. But on where does the document come from, we're not going to have the opportunity to cross-examine anybody else.
No, I'm just answering your first question, your first statement there.
As a broad principle, yes, but in terms of why we authenticate documents, it's not, and this is one of my least favorite phrases in international criminal law, is we're professional judges. Professional judges are everywhere, and yet we still have rules of admission and regarding foundation, et cetera, that precisely to avoid situations like this.
We do, but they are not you must admit the rules that we have use a prima facie level. They're not quite as strict as they might be in your country or your country. The levels are different.
We could argue about whether that level means there's no level at all.
No, there's a level, but
Okay.
it's a different level.
Okay, well, we're arguing about where that level is, I guess. So,
Okay.
thank you.
Thank you. Mr. Roberts, anything you want to add?
Nothing to add, Your Honour. Thank you.
Mr. Ellis?
Your Honour, only to endorse the concerns that others have raised, and we fully support the submissions made by the defence already. And just to emphasise on the point in relation, I think it was His Honour Judge Gaynor's question about the evidential status of the ICTY declaration. Your Honours have, of course, held previously that the panel will not base its assessment on reliability or probative value on material not offered for admission. That was in rejecting some submissions the defence had made about the admissibility of Rule 155 statements in filing F1603, paragraph 50.
Thank you, Mr. Ellis. Wish to respond?
Yes, Your Honour, very briefly. Firstly, counsel seek to raise the admissibility threshold far beyond what the jurisprudence I cited set it at. I also note that the ICTY filing referred to is publicly available, and the information we provided is that the SPO has about the information that we provided is what we have the SPO has about his provenance, but there are multiple indicia of authenticity and reliability as laid out in my earlier submissions. In particular, the mundane details in the document that I referred to earlier are strong indication of authorship by the KLA. The second document also lists others to be arrested, so its relevance is also generally broader than the witness and his co-detainee. And finally, it's not necessary to set aside every other inference for meeting the prima facie standard for admission. Thank you, Your Honour.
I have a question, counsel. Stay up. Mr. Ellis has helpfully reminded us of a prior ruling on the basis of our decisions of admission, in particular the fact that this panel, at least in its prior decision, was not prepared to rely on material not offered for admission. My question to you is what do you expect the panel to do with the affidavit, and if something, on what basis? Are you asking us to admit it? Are you asking us, or are you offering to call that individual?
We're not offering to call the individual. It's offered to your consideration. It's up to you whether you want to consider it or not.
And what about Mr. Ellis's point that should the panel wish to be consistent with itself, we should not consider it? You can take a joker if necessary on that one, but I think Mr. Ellis, in my view, has a point.
I would say that admitting the item, the MFI item, would be consistent with prior decisions. So that's my answer.
I believe we've heard all the submissions. We will take it into consideration. I am guessing you can all leave. We will probably submit this decision on Monday following.
I did have one issue to raise.
Certainly. Go ahead.
If we could do it in private session, Mr. President.
All right. One other question. Next week, 2 witnesses. Is that correct?
Yes, it's correct. It's
and
correct.
the same
Your Honor.
2 that you had projected?
Yes.
All right. Now, we'll go into private session. Your Honors, we're in private session. Thank you. Go ahead, Mr. Estich.
Thank you, Mr. President. I wanted to clarify something that may have arisen out of my recross-examination followed following the panel's questions at the end.
Your Honours, we're in public session.
We stand adjourned until 9 a.m. on Monday.
All rise.